Let's start with यूनिट 5 दैट इज लॉ ऑफ द सी. तो जैसे एक लैंड में डिफरेंट बॉर्डर्स होते हैं एंड उसकी टेरिटरी होती है दैट दिस पर्टिकुलर टेरिटरी दिस लैंड बिलोंग्स टू सच स्टेट, वैसे ही सी में भी होता है. एंड हियर बाय सी इट मीन्स दैट ओशन. सो ओशन इज ऑल्सो डिवाइडेड इनटू बॉर्डर्स एंड बाउंड्रीज, एंड उसमें किसकी jurisdiction होगी, विच लॉज विल बी एप्लीकेबल, एंड what type of divisions are there, on what basis it has been divided, all are given under the law of the sea. So under international law there is a separate branch which is known as law of the sea. So let's start with this unit. Introduction to the law of the sea. Law of the sea is a body of international rules and principles that governs the ocean spaces and the resources that it contains. It means that all the world's oceans, seas, and all the aspect of maritime issues, including boundaries, navigation, environmental conservation, resource exploitation, research, rights and responsibilities of nations and individuals, all are covered under law of the sea. But law of the sea is specific about the ocean spaces and its resources and nothing else, and all the issues that it covers. So this is the meaning and introduction of the law of the seas. Now let's see what is the historical context. So I have divided historical context in two parts, like first one is in brief and second is in detail. So it depends on you which one you want to write in your exam. If you want a lengthy one, then you can write the detailed historical aspect, and if you want to write a brief one, then you can use the brief one. So starting with the brief one. So the development of the law of the sea can be traced back to centuries, but modern international law began to merge in the 20th century with increasing maritime activities and disputes. So it is stating that the laws relating to the seas are centuries old. It means that they have been practicing by different states, but they were not formalized and they were not written anywhere. But in the 20th century there were industrialization going on, trading, international trading started, so the maritime activities and disputes started to rise a lot. So this gave impetus to law of the sea. Next very important development that happened is the UNCLOS, that is United Nations Conventions on the Law of the Sea. It was adopted in the year 1982. It is the main and primary international legal framework governing activities which is happening in the sea. So UNCLOS provides all the rules and principles that is relevant for the law of the sea. So if there is any dispute relating to the law of the sea, then we refer to the UNCLOS, since it is the first and primary international legal framework for the oceans. Now it has been ratified by nearly all nations except few, and the most shocking one is the United States. United States has not ratified. It means that it has not agreed and signed the UNCLOS yet. So UNCLOS is one more advantage is that majority of the countries have signed it. So it means that all the clauses under UNCLOS becomes obligatory on the ratifying country. India is also a member of UNCLOS. Next is the historical context in detail. So ancient civilization like Greeks, Romans and Egyptians, they developed the basic maritime laws and customs. Why they developed? Because they were involved in the regular trading and fishing activities in their respective regions. So as the activities evolved, they started having the basic laws, and this has provided a foundation for the law of the seas. Next is during the medieval and Renaissance period, treaties agreements between European powers shaped the maritime activities. There were different agreements between different nations, mostly European powers. So this led to the another development in the law of the sea. Then in 17th and 18th century, the concept of the territorial waters, sovereignty of water came, and the country started defining that these waters belongs to this state, so this is our territorial water, we have sovereign right and jurisdiction on these waters. So such concepts came in the century 17th and 18th. Let's see what happens next. Again in the 17th century, the concept of freedom of the seas came, and it was favored and advocated by the jurist Hugo Grotius, who is also known as the father of the international law. So he said that the sea belongs to everyone, so it should be open for navigation and trade for all. and in the 19th century we expanded the industrial revolution, and because of this revolution economic boom was witnessed. So illegal issues like piracy, slave trading, and conflict over territorial waters intensified. This resulted in more agreements and international treaties between states to address the problem of navigation, piracy, then rules governing their territorial waters. So industrial revolution gave us more international treaties and conventions. Then in the late 19th and early century saw the establishment of legal framework through the Conference of Hague Convention, which happened twice, that is 1899 and 1907. So this Hague Convention laid the groundwork or foundation for the maritime laws. Next, the most important part is the UNCLOS. This has paved the way for law of the sea, and it provides us the legal principles and customary practices that we were having for centuries. So this UN clause was drafted after taking all the previously existing maritime foundations and bases in consideration. So UN clause consolidated these principles and customary practices. UNCLOS is a framework for providing for various maritime zones, navigation rights, rules, environmental protection, resource management, and dispute settlement. So this is the history behind the law of the sea. So this particular picture will help us in understanding the maritime zones, which is divided by the UNCLOS. So UNCLOS provides us these different zones. बेसिकली इसका मतलब है बाउंड्रीज और पर्टिकुलर स्पेसेस ओशन में, जिससे हम लोगों को राइट्स, रिस्पॉन्सिबिलिटीज एंड जुरिस्डिक्शन पता चलता है. सो लेट्स स्टार्ट विद द लीगल जोनिंग. सो दिस इज एनी स्टेट, उसके स्टेट से यहाँ पर बेस लाइन होता है. दिस इज द बेस लाइन, एंड फ्रॉम बेस लाइन to 12 nautical miles starts the territorial sea. This sea belongs to the state. इसमें जो भी करना है, fishing activity, navigation, exploration, everything can be done by the state whose baseline is here. तो अगर ये इंडिया है तो इंडिया का ये बेसलाइन है, और यहाँ पे 12 nautical miles तक territorial sea है. अब nautical miles क्या होता है? ओशन को हम लोग किलोमीटर्स में मेजर नहीं करते, we measure it in terms of nautical miles. So from baseline till 12 nautical miles is the territorial sea. फिर उसके बाद स्टार्ट होता है इकोनॉमिक एक्सक्लूसिव जोन. ये जोन होता है जिसमें स्टेट के पास राइट होता है अपना जुरिस्डिक्शन एक्सरसाइज करने का, डिफरेंट नेविगेशंस करने का, एक्सप्लोरेशन करने का. ये इकोनॉमिक पर्पसेस के लिए होता है, जो डेवलपमेंट में हेल्प करता है. उसके नीचे जो सी बेड है, दैट इज नोन एज कॉन्टिनेंटल शेल्फ. सो दिस शेल्फ इज ऑल्सो देयर. सो दिस इज ऑल्सो अनदर डिविजन. अब एक्सक्लूसिव इकोनॉमिक जोन के बाद आता है हाई सी, एंड हाई सीज आर ऑल्सो नोन एज इंटरनेशनल वाटर्स. देयर इज नो क्लेम ऑन दिस एरिया बाय एनी कंट्री. तो यहाँ पे जो भी डिस्प्यूट होता है, कुछ भी होता है, उस पर कोई भी क्लेम नहीं है, एंड वो मैटर आईसीजे डिसाइड करता है. नेक्स्ट, हाई सी के नीचे जो सी बेड है उसको बोलते हैं डीप सी बेड. इसको एरिया भी बोलते हैं. ये जो एरिया होता है, दिस इज ऑल्सो ओपन फॉर ऑल. मतलब इसमें कोई भी कंट्री क्लेम नहीं कर सकता दैट दिस सी बेड बिलोंग्स टू अस. तो मोस्टली ये सी बेड यूज होता है डीप माइनिंग के लिए, मिनरल्स वगैरह एक्सप्लोर करने के लिए. सो this is the particular division: territorial sea, exclusive economic zone, continental shelf, high sea and seabed. यहाँ पर एक continental contagious zone भी आता है. So that we will see in another slide. So through this picture we can understand the distance and the nautical miles that has divided the maritime zones. We can also call them as borders in layman language. So starting from the baseline, we have the territorial sea. So the distance from baseline till the distance territorial water ends or territorial sea ends is the 12 nautical miles. And from here starts the contagious zone, and this contagious zone starts for 12 nautical miles again and stops at 24 nautical miles. Now comes the exclusive economic zone. So exclusive economic zone starts from territorial seas border and ends after 200 nautical miles, and below the exclusive economic zone is the continental shelf. This is the seabed. मतलब ये ओशन वाटर इकोनॉमिक एक्सक्लूसिव जोन है, बट यही जो पूरा यहाँ 12 नॉटिकल माइल्स है, 200 नॉटिकल माइल्स है, वो कॉन्टिनेंटल शेल्फ है. Now, after 200 nautical miles comes the high sea, and high sea is the international water. और उसके नीचे का जो ओशन बेड होता है उसको हम लोग एक्सटेंडेड कॉन्टिनेंटल शेल्फ भी बोलते हैं, और उसके आगे वाले को हम लोग बोलते हैं सी बेड, and this is also called as the area. So under this there is no jurisdiction, and these are international waters and open waters which can be used by any state for any exploration purpose, for any navigation, military, shipping, and these areas have other jurisdiction, like under territorial sea is the jurisdiction of the state, under contiguous zone jurisdiction of the state, under exclusive economic zone continental shelf the state can exercise its jurisdiction for exploration, for resources purpose, but this area belongs to the international waters. Let's see territorial sea and water in detail to understand more about its jurisdiction, sovereign rights of a state. So here is a picture for the better understanding. So here is the territorial water, which starts from the baseline and extends till 1200 nautical miles in the ocean. So under this, the state is having complete sovereign right over the airspace. This is the airspace, water column, seabed and subsoil for exploiting and exploring the resources. And also in this territorial water the state is also having the right of imposing any rules or laws relating to the right of passage, कि कौन सी कंट्री के शिप्स या कौन से कंट्री के वेसल्स क्रॉस कर सकते हैं, एंटर कर सकते हैं टेरिटोरियल वाटर्स. दीज आर ऑल्सो with the concerned state. So there is absolute sovereign rights reserved with the states in terms of territorial waters. So here we find this new term, that is internal water. So this is before the baseline, और उससे पहले जितने भी water होते हैं that is known as internal water. So this does not come in the maritime zones, but maritime zone starts from the territorial waters, that is 12 nautical miles from the baseline. Now come the contagious zone. So contagious zone is basically to protect the territorial waters and the territory of a state. So this is of 24 nautical miles. So 12 from the baseline, 12 nautical miles of territorial waters plus 12 nautical miles makes a contagious zone. So it is of 24 nautical miles from the baseline. So the purpose is to protect the interest of the maintaining the order in the areas adjacent in the territorial sea, meaning that this works as a safe zone. Like if there is any threat to the land, to the state, then they have to come through this. So contagious zone is there to prevent them or to slow them down to enter the territorial waters. The contagious zone is also related to matters relating to fiscal, immigration and health. So this zone helps the state in protection of the territorial waters and sea, and also to make specific laws relating to customs, fiscal matters and immigration. Now control rights. So coastal states can prevent and punish violations of their laws within contagious zone, extending their jurisdiction beyond the territorial sea. So again, we know that the territorial water, over the territorial water the state has sovereign control. Similar is the case with the contagious zone. So if any vessel, ship or any state violates any law by entering the contagious zone or doing any activity which is a violation under international law, then the concerned state has all the right to punish and prevent such state. So this was contagious zone, which is 24 nautical miles from the baseline. Exclusive economic zone. So from baseline till 200 nautical miles is the exclusive economic zone. So till that 200 nautical mile zone, the coastal state has all the sovereign right over the water columns, subsoil, seabed to explore and exploit it. Then they have also the right for exploring, exploiting, conserving, managing natural resources that is available within that zone. जुरिस्डिक्शन के मैटर में कोस्टल स्टेट के पास पूरा जुरिस्डिक्शन होता है साइंटिफिक रिसर्च एंड एनवायरमेंटल प्रोटेक्शन का विद इन दिस जोन, एंड ऑल्सो दे कैन रेगुलेट मरीन साइंटिफिक रिसर्च विद इन एक्सक्लूसिव इकोनॉमिक जोन. Now comes the interesting part, and this makes exclusive economic zone different from contiguous and territorial waters. So under this, states can have certain rights like freedom of navigation, overflight, laying of submarine cables, pipelines and fishing. But again, it is subject to the coastal states regulation. अगर कुछ regulation है states का जो ये सब को prevent करता है, then they cannot have it. अब यहाँ पे overflight का मतलब क्या होता है? It means that plane can go over this exclusive economic zone without taking permission of the coastal state. So these are some of the rights other states can enjoy in EEZ. Next is the continental shelf. So continental shelf starts from the baseline till 200 nautical miles. So it is equal to the exclusive economic zone. So we can say that exclusive economic zone is the water part and continental shelf is the seabed or subsoil. तो जितना बेस लाइन से स्टार्ट होके एक्सक्लूसिव इकोनॉमिक जोन का बॉर्डर है, उतना ही बेस लाइन से स्टार्ट होकर कॉन्टिनेंटल शेल्फ का भी बॉर्डर है, बट एक्सक्लूसिव इकोनॉमिक जोन इज द वाटर एंड कॉन्टिनेंटल शेल्फ इज द सी बेड. So the state has sovereign rights over the exploration and exploitation of natural resources that is in the continental shelf, and the continental shelf can be used for exploitation or exploration of natural resources such as gas, oil and minerals. So the state has proper jurisdiction, sovereign rights over the continental shelf. So this is the baseline, and this is the continental shelf. High seas. So high seas can be called as international waters. There is no claim of any state of high seas. So it is those areas of the ocean which is beyond the exclusive economic zone, that is starting from baseline till 200 nautical miles. After that is the high seas. So this is the baseline, and from here 200 nautical miles is the exclusive economic zone, and afterwards of 200 nautical miles starts the high seas. So this is the area where it is open for all the states to conduct activities like navigation, fishing, laying cables, conducting scientific research. So this area has no jurisdiction claim from any state. Now international access. So 2-3 states can work in cooperation and make use of high seas for mutual benefits, like promoting some global connectedness, like they can lay cables or exploring or exploiting some resources together to benefit equally. Next, areas and rights. So these areas are not under authority of any single state, providing freedoms for various activities and ensuring the benefits are shared among all nations. So there is also one interesting thing about high seas is that if any benefit is found in the high seas, then it has been said under international water that the benefit or the knowledge should be shared with all the nations, so that there should be a global and mutual benefit from the high seas. Delimitation of maritime boundaries. So it is one of the important concept which helps in drawing or establishing limits and borders between two opposite or adjacent countries. Here I have taken example of Peru and Chile. So 200 miles from Peru's baseline is here, and 200 nautical miles from Chile's baseline is here. So there is this overlapping. So this maritime boundaries was decided on the principle of equidistance line, that there should be equal distance for both in terms of boundary and borders in the ocean. So this maritime boundary is important because it determines the rights and responsibilities over maritime areas, and also it provides certain features like bays, rivers and fringing islands, which is very essential in terms of maritime boundaries. Now comes the principles. So this delimitation of maritime boundaries is done basing on the principle like equidistance, equity, and there are some relevant circumstances where the decision is being made. So there are some famous cases, that is North Sea continental shelf cases, then Libya versus Tunisia, Bay of Bengal maritime boundary arbitration. These are some of the cases that was trial, and the border was determined by using these principles. Let's understand these cases in detail so the concept of delimitation of maritime boundaries can become more clear. So the one of the famous cases, the North Sea continental shelf cases. This was between four countries, that is Germany, Denmark, Netherlands and Norway. This was over the dispute of drawing the borders. So here I have included the map. So we can see Norway, Denmark, Germany and Netherlands. So all of them are here, and we can see that 200 nautical miles from each of the countries' distance can be complex. There can be overlapping, there won't be proper boundaries to mark the jurisdiction. So this case was filed in ICJ in the year 1969, and ICJ made a very significant ruling and applied the equitable principles and other legal criterion while deciding the border. So it means that every state here, all the four states will get equal distance in the border. It means that not taking accountability of exact 200 nautical miles, but they all will get equal ocean water in terms of maritime boundaries. Now next come Libya versus Tunisia continental shelf case. So here again I have included the map, and we can say Libya is here, Tunisia is here. So again marking the 200 nautical miles can become complex. There can be overlapping, so it can cause jurisdiction dispute. So in this case the court helped in clarifying principles related to maritime boundary delimitation and decided the matter in terms of equidistance. Republic of Italy versus Union of India 2013. This case is also known as Enrica Lexi case. So this case involves the issue of maritime boundaries and how those boundaries are determined. So in this case what happened, there were two Indian fishermen who were doing fishing in the exclusive economic zone of India, and in that particular area was an Italian ship where two individuals shot these fishermen thinking them as of pirate. So here the India tries to convict them or tries to bring them for the trial, where the Italy filed an appeal in the ICJ stating that they do not have jurisdiction over these Italian foreigners. So the ICJ claimed that the incident happened within the exclusive economic zone of India, so India has full sovereign right to try these Italian nationals. So this issue and legal principle applied by the courts helped in deciding the jurisdiction matter in the maritime boundaries. Next comes the Bay of Bengal Maritime Boundary Arbitration, and this was a issue over the Bay of Bengal between India and Bangladesh, between drawing the borders in the maritime zone. So the Permanent Court of Justice in 2014 gave the decision based on equitable principles in international law, that both the countries India and Bangladesh should get equitable or equal boundaries so that they have equal access in their zones. Next is the maritime delimitation in the Indian Ocean, Somalia versus Kenya. So this case is still ongoing, and it is expected that the ICJ is going to give a decision on the basis of equitable principle that is being going on in the maritime boundary. Under international law exists some concept which talks about fairness and equitability, and what such concept is common heritage of mankind. So this concept talks about equitable and fair distribution of benefits derived from some areas which should be reserved for all the mankind and should not only belong to individual states and corporation. So this concept emerged in the 1960s and 1970s in response to concerns about the equitable management and exploitation of resources that are beyond the national jurisdiction, that is beyond the exclusive economic zone. So this is the deep sea bed, and later on deep sea bed was joined with outer space. So these two are such areas which should come under common heritage of mankind, that the all the benefits that is being derived from these heritage should be shared equally and fairly with all the states irrespective of their technological and economic capabilities. So this principle talks about equitable access of benefits for entire world. To deal with this, UNCLOS has established the International Seabed Authority ISA, and ISA manage and regulate the activities which is going on in the international seabed area. So this international seabed area is that area which is beyond the national jurisdiction, that is after the 200 nautical miles from the baseline of a coastal state. So what is the role of ISA? So ISA ensures that seabed mining activities are carried out only for the benefit of the mankind as a whole and not resulting in some devastating environmental impact. Also, ISA set rules and regulations and procedures for exploration and exploitation with a more focus and emphasis to the environmental protection and equitable sharing of benefits. So this concept is also dealt in another slide in detail. So let's understand that. Principles guiding ICA. So there are two principles. First is benefit sharing, second is environmental protection. So these two principles are considered by ISA while regulating and monitoring the activities that is going on in these deep seabed areas. So the benefit sharing can be in the form of royalties, financial arrangements, and also knowledge. It does not mean if some corporation or state has found something, they have to share it equally. They can share it in the form of royalties, financial arrangements, or also knowledge what they have gained from it. And also another principle is environmental protection. So they regulate the marine resources and tries to protect the marine environment considering the long-term interest of humanity. So these are some of the common heritage of mankind. Antarctic, in Antarctic any state can explore and exploit it. Similar is the outer space. There is no claim of jurisdiction in the outer space. Moon is same. Any country can go in the at the moon for research purposes, for exploitation, exploration purpose. High seas, this is after the exclusive economic zone of from the coastal seas. This is seabed. High sea के नीचे seabed आता है. So these all belongs to the common heritage of mankind. So the benefits should be shared equally. This is the principle what it says, but there are certain criticism and challenges while implementing this principle. So this is what a seabed mining looks like. This is the high sea, and beneath that is the surface of the ocean, and in that the mining is conducted, and it is called as international seabed mining. So this seabed mining is done for extraction of minerals and resources from the ocean floor, and these minerals and resources are used for the advancement in the technologies and to increase the global demand for metals and minerals that are found in these seabeds. So regulation, we know that UNCLOS has established a legal framework, and also it has established ISA, which regulates and manage mining, and ISA looks over the regulation of it and tries to promote equitable resource distribution. Current status and future outlook of international seabed mining is that there are still concerns going on regarding the balancing of development, economic development, and also environment. So there are various calls from the environmentalists for precautionary approaches, and this rigorous environmental damage can result in long term damage to the entire world. So the environmental concerns are rising in the current status and future outlook. India's maritime interests, policies, and laws. So these are very important for India since it provides for economic stability, environmental objectives, and also strategically important for India. Since India is having water from three sides, so it helps India in combating piracy, countering maritime terrorism. So India is very much focused on maintaining maritime policies and laws, and also geostrategic position. Since India is at the crossroad of major shipping routes, India is using this advantage, this geographical advantage, for making economic growth and global trading. Next is the environmental concern. So India stands for environment and it advocates actively for combating climate change and to promote sustainable fisheries management and to preserve coastal marine ecosystem and also to combat marine pollution. So India stands for environmental concerns. Now comes the legal framework. So in 1995, India agreed and signed and ratified the UNCLOS, meaning that all the rights, responsibilities mentioned under the UNCLOS is applicable to India. This means that the maritime zone is also divided as per the UNCLOS, making territorial waters of 12 nautical miles from the baseline, contiguous zone 24 nautical miles, EEZ 200 nautical miles, and below that the continental shelf. Also, the maritime jurisdiction. India exercises jurisdiction over its maritime zones, regulating activities such as navigation, fishing, resource exploration and exploitation, and also promotes environmental protection and disputes related to maritime boundaries. So this is the India's interest in the maritime laws, and it makes policies and laws as per the UNCLOS, इंटरनेशनल ट्रिब्यूनल फॉर द लॉ ऑफ द सी, शॉर्ट में इटलॉस भी बोलते हैं. सो यूएन क्लॉस एस्टैब्लिश्ड इटलॉस and it came into force in the year 1994. It is having its headquarter in Hamburg, Germany. जुरिस्डिक्शन क्या है इसका जुरिस्डिक्शन है सारे मरीन रिलेटेड एक्टिविटीज पर, इंक्लूडिंग मैरीटाइम बाउंड्रीज, फिशरीज, marine environment, navigation rights and any other issues arising from the UN clause. So it has the function and responsibility of adjudicating all the cases submitted by states and international organizations relating to maritime disputes. This also includes the advisory opinion which United Nations General Assembly or any other state takes from it. Next is its function is prompt release cases. इसका काम होता है जल्दी जल्दी केसेस सॉल्व करना, सो दैट देयर शुड बी रिलीज ऑफ वेसल्स और क्रूज डिटेन्ड ड्यूरिंग द मैरीटाइम डिस्प्यूट्स. नेक्स्ट इज कंपल्सरी jurisdiction. So the state parties, the states who have signed or ratified UN clause can choose ITLOS as a forum for settling dispute by declaring it that they are having the compulsory jurisdiction. So advisory opinion can be given at the request of international organizations, state parties or United Nations on interpretation of UN clause. So ITLOS is a tribunal specially for the maritime dispute which was established by the UN clause. That was all in your unit 5 relating to law of the sea. I hope you all understood it very well. So a long question may come from this unit directly relating to the laws under UN clause relating to the maritime, and short notes may come on common heritage of mankind, then explaining about the different maritime zones that are mentioned under UN clause. So use the cases, use the points in writing a good answer so that you can fetch good marks. So all the best for unit 5.